So we want to bring up our next speakers. If you could come up and sit up here, and you can come up to the podium when your turn comes. But I want to introduce the moderator of this panel. And the moderator of this panel is somebody who has many, many, many qualifications to speak on this issue. She is a professor of human rights at the Thomas Jefferson School of Law. She is the former president of the National Lawyers Guild. She is also a criminal defense attorney and a representative on the executive committee of the Association of American Jurists. She is an author of many books, and her latest one, which will be coming out next year through the University of California Press, is called Drones and Targeted Killing: Legal, Moral, and Geopolitical Issues. Let's give a hand to Marjorie Cohn.
Thank you so much, Medea, for that introduction and for the incredibly courageous work that you do every day of the year in our name to organize us and to stop the madness and stop the killing. Thank you, Medea. Besides being immoral and ineffective in stopping terrorism, in fact, drone strikes and targeted killing make us more vulnerable to terrorism. Drone strikes and targeted killing off the battlefield are illegal, and that's what this panel is about. We have some wonderful speakers today, and I'm honored to be on the same panel with them. Professor Mary Ellen O'Connell and Pardiss Kebriaei. I'm going to briefly tell you about them, and then Mary Ellen will give the international law framework for this whole issue of targeted killing, and then Pardiss will talk about accountability for drone strikes. She has been the attorney in 2 of the Awalaki cases, and then I am going to talk about the U.S. government's justification for drone attacks and targeted killing, and talk about some of the pending legislation. Then we'll open it up to questions and answers. Mary Ellen O'Connell is a renowned expert on international law. She writes and speaks widely about targeted killing. She is a research professor of international dispute resolution at the Kroc Institute and the Robert and Marion Short Professor of Law at Notre Dame. She's held that position since 2005. Mary Ellen chaired the Use of Force Committee of International Law Association from 2005 to 2010. She is currently vice president of the American Society of International Law. From 1995 to 1998, she was a professional military educator for the Department of Defense in Germany. Pardiss Kebriaei is senior staff attorney at the Center for Constitutional Rights. She challenges government abuses post 9/11, including targeted killing and also abuses at Guantanamo. Pardiss is the lead counsel for CCR in Awalaki versus Panetta, which seeks accountability for the killing of 3 U.S. citizens in U.S. drone strikes in Yemen. She is counsel in Awalaki versus Obama, which is challenging the authorization for the targeting of a U.S. citizen placed on the government kill lists. It's my pleasure to first introduce Mary Ellen O'Connell.
So my title is International Law and Drone Strikes Beyond Armed Conflict Zones. But my point today is to clear up the mounting myths that it is lawful to kill people with the use of military force represented by the drone, which fires the Hellfire missile, a weapon only lawful on a battlefield under international law. As one of the questioners posed to Dr. West, we're seeing increasing problems with the law through this whole drone campaign. Most precious of all are the human lives that are being mangled by drone attacks, but also God's natural creation, which we never hear about, wildlife, landscape. But in addition, the law is being mangled through the use of drones and the president's attempt to continue to try to justify the use of drones. This January, as Medea said, will be marking the 5th anniversary of the start of President Obama's very public drone attacks in these 3 countries, Yemen, Somalia, and Pakistan. The first of the drone attacks outside of an armed conflict zone occurred in Yemen in November 2002. The Los Angeles Times did extensive reports, but the Bush administration never formally acknowledged the attack because it was supposed to be a covert mission that they wouldn't comment on. The CIA operated that drone in the very first attack in Yemen. It was a Predator, and they launched it from Djibouti on the African East Coast. 6 people were killed, including a 23-year-old American from upstate New York. None of the people was involved in fighting at the time, and in fact, there was nothing in Yemen at that time that amounted to an armed conflict. In fact, it was safe enough for the CIA to send a helicopter to the attack site, send 2 agents down by ropes to the ground, take DNA samples from the victims, get back into the helicopter, and fly away. No danger to them at all. The one intended target, a man named al-Harithi, was not even involved in 9/11. The Bush administration then expanded its drone campaign to Pakistan in 2004. Again, it refused to comment on any reports of drone attacks, and in fact never commented on whether there was any legal basis for drone attacks. It moved on in 2006, or early 2007, to Somalia, where it again deployed drone attacks. In 2008, during the presidential campaign of candidate Barack Obama, we heard criticisms from Mr. Obama that the so-called global war on terror, under which Guantanamo was allegedly justified, under which techniques of interrogation amounting to torture were justified, was not something that we could tolerate in this country. A war with no limits in terms of geographic space or time. That's what President Barack Obama said while he was campaigning in 2008. He rightly said there was no such thing as a global war on terror. Yet in January 2009, just a day or 2 after he signed those executive orders ending the use of harsh interrogation and an order, remember, to close Guantanamo, he authorized drone attacks in Pakistan that killed, according to a report by Jane Mayer in The New Yorker, killed 20 people, including an entire family of a local leader who was against militant Talibanism. Not only did the leader die, his entire family died, including 3 children, including a 5-year-old. That did not lead to President Obama hesitating for a moment. In fact, the drone attacks continued. President Obama authorized a doubling of the drone attacks in Pakistan over his predecessor, President Bush, during the course of 2009 when compared with 2008. By that time, by the time of 2009 and this doubling of attacks with its hundreds of victims, I had already published numerous articles and book chapters explaining as clearly as I could that under international law, there could be no such thing as a global war on terror. I criticized that concept as well as I could under international law and specifically pointed out how places like Guantanamo were anathema in the law, as was torture, of course, but also targeted killing. By the fall of 2009, I had put on line a book chapter that I've been working on for the previous year, a case study of unlawful killing with combat drones in Pakistan. And there was apparently some attention to this rather lone voice of an obscure law professor in the Midwest at Notre Dame, because in the spring of 2010, at the American Society of International Law, where I was vice president at the time, Harold Koh, a dean of the Yale Law School, someone who cared very deeply about his own reputation as a champion of human rights. He was working for the Obama administration in the legal advisor's office of the State Department. He was Obama's lead international lawyer. He stood up in front of an audience of 700 of us and tried to tell us why, under international law, it was perfectly lawful to kill all these people in non-armed conflict zones with drones. I stood up and said to him, but Harold, what you're saying is nothing different than the global war on terror that President Obama criticized. And he shouted back, Mary Ellen, I did not use those words. I did not call it a global war on terror. It is an armed conflict against al-Qaeda, the Taliban, and the associated forces. And I just said, Harold, I've been a law professor almost as long as you. I see no legal difference between those concepts. Apparently, they were feeling a little bit uncomfortable by then. And after Harold Koh spoke to us about this, his attempt at legalization, we kept hearing more attempts, different ones. I by now count 5 or 6 different, very complicated arguments, drawing on international law here and there, but really manipulating the law, really trying to find something that might convince allies, the public, the Congress, that what we're doing is lawful and ethical. 5 arguments and then another 3 by sympathizers. And in fact, those sympathizers have now moved on. Many of my colleagues in international law, particularly in this country, and in trying to, but also sadly in the UK, to make arguments that we should change the law. If O'Connell is right and there's no legal basis for this, well, fine, this is so important that we're going to change the law. And this is my own personal work of the moment, my own personal activism is to meet these arguments as often and as thoroughly as I can, and to call upon my good colleagues like Marjorie, like Pardiss, to continue to support the law as it was written, the law that I'm about to talk about in a little bit more detail with you, and not allow this manipulation and this change to whitewash unlawful killing with drones. The law we have, the critical and important law that we have, begins here. This is the heart of the United Nations Charter. This is Article 2, Paragraph 4, written in 1945, really written by our President, Franklin Roosevelt, at the end of that cataclysm of the Second World War. And what the UN was to stand for was to save succeeding generations from the scourge of war. And the legal means to do so was through this provision, Article 2.4. It is a general prohibition on resort to military force. It is a general prohibition on resort to military force. It does not permit you to use force if you think it's necessary, if you think it will show your countries more powerful than other countries. You are not to use military force. There are only 2 narrow exceptions, and one the UN Security Council told us we could invoke after 9/11. That was Article 51. But look at Article 51. This is the provision on self-defense. It allows only a very narrow right to resort to force in self-defense. If an armed attack occurs, and we know from additional international law, the armed attack has to be drawn to a state if you're going to counterattack on the territory of that state. That is critical for our understanding of the law related to drone attacks. If the President says we're doing this under Article 51 of the UN Charter, it has to be against an armed attack. There was only one place that the British told us was a sufficient case in law to bring that armed attack, and that was Afghanistan. I no longer believe the facts that were developed by the British, and I'm very sorry for my own failure to be more critical in reading their case against the Taliban in Afghanistan. But on October 7th, when the U.S. first invaded, at least until the Taliban fell in December 2001, it seemed to me that there was a case under Article 51. But in that place only, that was the place where we believed our legal case for state responsibility for 9/11 lay, and it didn't lay in Pakistan or Yemen or India or Indonesia or any of the many other places where members of al-Qaeda exist. In fact, my committee on the use of force, which comprises 18 people, some of the world's leading experts on international law from 15 countries, including 5 continents. This was a truly international, truly expert committee. And our finding was that the only places where you can say that there is such a thing as armed conflict are where you have the existence of organized armed groups that are actually engaging in armed fighting. Today, there is only one place where the United States is in such a war, and that's that war that began under the premise of self-defense, and that's in Afghanistan. Since 2002, it has not been a war of self-defense. It has been a war at the invitation of Hamid Karzai to suppress a rebellion, another impossible basis under international law, but that basis does not extend to any other place. To lawfully use force in Pakistan, Yemen, or Somalia, we have to meet these principles. There has to be a basis, as I just mentioned, under Article 51, perhaps, of self-defense, but none of these countries have attacked the U.S. Or with UN Security Council authorization, it has not authorized the U.S. to attack anywhere except where there's state responsibility under Article 51. Invitation. We have one colorable invitation. That's in Afghanistan. We do not have an invitation to use military force in Pakistan, certainly not by the elected president of that country. We do not have appropriate invitation from Yemen because I do not believe that their current leader has that legitimacy to invite the United States in, and nor is there really at this point, is the U.S.'s military effort in Yemen based on a civil war within Yemen. But even if we had a basis, you must also meet these important general principles of international law, necessity and proportionality. Look at what necessity requires. Last resort. That you've tried everything else. You've tried negotiation. You've tried law enforcement measures, and those don't work, even if you have a basis. And I tell you that that basis, that principle alone excludes the lawful right of using drones. Also, you have to think that you have a chance of success. But the best counterterrorism information shows us that law enforcement measures, not military force, is what works to have long-term success in suppressing terrorism. We do not have a chance of success using military force. Finally, we have to think about proportionality. We heard from Medea about the kill list. Apparently, President Obama has been trying to get no more than about 24 people on his kill list. How many have we killed? The Bureau of Investigative Journalism has figures of well over 4,000 persons killed. This is not a proportional way to resort to force. And if you don't meet those basic principles of legality, you're not meeting our modern understanding of just war, of morality. So, all of this killing has been going on, but we already knew in 2003 when the brave Pakistani human rights lawyer Asma Jahangir, the UN Special Rapporteur for Extrajudicial Killing, told the United Nations that that first attack in Yemen in 2002 was extrajudicial killing and unlawful. We haven't needed all of these new reports from the UN. We already knew from Asma in 2003. Nevertheless, we've had report after report, and they all continue to criticize. And apparently our Attorney General knows that this kind of killing is unlawful because he said it's not lawful to do it here in the United States. Well, if it's not lawful to do it here, if there's no global war on terror here, then how can it be other places? This is where al-Qaeda did their worst attack. But he knows it's not lawful. Rather, what we're doing here in the United States is meeting the principles of international human rights law. We're holding our police forces to this principle that they may only deploy lethal force to save a human life immediately. That's what international human rights law requires with regard to government authorities resorting to lethal force in areas where there is no armed conflict zone. That is the law that we apply here in our own country, because that's the law we have to apply to meet our fundamental legal obligations, our jus cogens obligations to protect the right to life. There is a division between war and peace. We have definitions in international law of what an armed conflict is. Outside those areas, we must hold our authorities to law enforcement, and you cannot deploy lawful law enforcement using a Hellfire missile. In May, at the National Defense University, President Obama, too, indicated the weak international law basis for these killings. He referenced, again, this renamed global war on terror. He referenced Article 51. But when Medea Benjamin broke into his speech demanding the end of drone attacks, he didn't say, President Obama didn't say, Medea, you're wrong. What I'm doing is perfectly lawful under international law. I've got the best international law minds agreeing with me, and therefore you're wrong, sit down. We can do this. No, what he said was the voice of that woman is worth paying attention to. So far, the president has not done so. As drone attacks continue, they are still continuing. Yes, the numbers have gone down, and we should be grateful for that, and we should praise the president for that. But in some ways, I'm even more concerned about some of the drone attacks that have gone on since May 2013. In October, the Bureau of Investigative Journalism reported on one strike in Pakistan that killed 5 people, including a man named Hakimullah Musaad. Probably better pronounced Masood. This strike came after the Pakistan Ministry of Defense released a figure of 67 civilians killed, in contrast to the Ministry of Foreign Affairs, which had just given Ben Emerson of the UN a figure of over 400. I find that very suspicious. After the death of Masood, President Sharif's planned peace talks with the Taliban came to an end. I believe we are yet to hear from good investigative reporters more details on this sequence of events. A very friendly figure of civilians killed right at a time when Amnesty International, Human Rights Watch are giving their very high numbers, are really getting the attention of the international community. Documentaries like Unmanned are coming out, and then this very low number comes from Pakistan in direct defiance of the Ministry of Foreign Affairs' own numbers. And then this man named Masood is killed, somebody who we know the Pakistani military and ISI did not like, and I think we know that those two branches of the Pakistani government were not interested in the president's peace talks. That has me very concerned. If the U.S. is carrying out drone strikes on behalf of the unelected military of Pakistan in defiance of the president's own wishes, we have yet to see good reporting on that very important message. Amnesty International's excellent report on civilian deaths has this young girl asking, will I be next? We know that her chances today of being killed by a drone attack continue, but it's far more likely she's going to be the victim of an internal terrorist attack in Pakistan without lawful and effective counterterrorism measures. I would like to see the U.S. begin a program of reparations for all of the violence that we have done. But I want to see it in a very particular form. I want to see the United States begin to support peace, resources, peace talks, to provide the kind of support and resources necessary to rebuild the criminal justice system of the 3 countries where it's been attacking, to help develop the economy so there are jobs, alternatives for people from joining militant organizations, through its actions, to reject the unlawful use of drones and take concrete action for peace, reconciliation, and anti-terrorism throughout the world. Thank you very much.
Hi, everyone. Thank you for being here. It's really energizing to see this size of a crowd. And thank you so much to CODEPINK and all the co-sponsors for hosting this. I'm an attorney. I'm Pardiss. I'm an attorney at CCR in New York. My work in this area, along with my colleagues, began in 2010 when we in the ACLU filed a case challenging the Obama administration's authorization, advance authorization, for the targeted killing of a U.S. citizen in Yemen, Anwar al-Awlaki, who they have sort of made the face of this program. I'll talk more about our litigation in a minute, but I just wanted to back up from the law for a minute and just remind us of the impact of this program. Mary Ellen talked about some numbers. You've heard numbers before. We know about some of the fact-finding reports that have been out. But just to say, because it's staggering, and I think we've lost a sense of scale, at the low end, at conservative estimates, 2,500 people have been killed. That's conservative. At the high end, over 4,000 people have been killed. That doesn't include those injured, and injury is sort of a sanitized word. It doesn't really describe what that means. People who've been burned, people who've been traumatized, people who've been psychologically terrorized. And it doesn't include their families who are struggling with loss. So the impact of this program is really staggering. These deaths and injuries are from over 430 U.S. strikes firing missiles in countries outside the war in Afghanistan or outside of quote-unquote hot battlefields, as the administration says, in at least Pakistan, Yemen, and Somalia. We don't know exactly where else because the government won't say. And as you heard Mary Ellen say, the administration claims that all of these actions, this entire program, is lawful because the United States is engaged in an ongoing 12-year world war against al-Qaeda and unspecified associates and may use war force outside of actual war zones. But if the universal principles that Mary Ellen discussed say that, one, war was meant to be an exceptional emergency state, that the laws of war are meant to be exceptional rules, that the resort to military force in the territory of other states is meant to be generally prohibited, except for narrow exceptions, and that killing is meant to be generally prohibited, except for narrow exceptions, then there is something fundamentally off base about the government's position. And the exceptions to the prohibitions on military force and killing have really swallowed the rule. In his speech in May, in his big speech at May at the National Defense University that Marjorie is going to talk more about in more detail, President Obama talked about or suggested sort of a scaling back of this program. He announced a new presidential policy guidance that calls for a few new criteria that seem ostensibly narrower. He said there must be a continuing and imminent threat, there must be the infeasibility of capture, and there must be near certainty that civilians won't be killed before the U.S. will conduct strikes in areas outside of active hostilities. That guidance is classified, so what we have about it is a speech and a White House fact sheet. But as far as imminence, let's look at what we know. We know from a leaked Department of Justice white paper that was leaked last February that discussed the government's belief of its authority to kill U.S. citizens, that the Justice Department or its lawyers define imminence as not requiring clear evidence of a specific attack in the immediate future. So, seems that what's that? Imminence does not require, this is in the memo or in the white paper, does not require clear evidence of a specific attack in the immediate future. But yet it's imminent. What the administration means by capture being infeasible is completely unclear. Again, we've got a speech and a fact sheet. And how meaningful it is to say that there must be near certainty that civilians won't be killed depends in part on how the administration is defining civilian, on how it's defining who can and can't be lawfully targeted. Even if these are meaningfully tighter standards, they are policy standards. They are discretionary. They are not the government's statement of what it believes it is legally bound to. In his speech, Obama reasserted the same World War premise of this program, even as he talked about a future where the U.S. would no longer be in continual warfare, which ostensibly means that the administration thinks that its legal authority, the outer edges of its authority, are far broader than these criteria that it has outlined. And in fact, in August, the Washington Post and the New York Times quoted senior U.S. officials who said that an alleged threat to the U.S. Embassy in Sana'a and elsewhere in the Middle East expanded the scope of people the administration believed it could go after in Yemen beyond the new restrictions. So we've got anonymous statements anyway saying that, in fact, yeah, these are discretionary policy criteria, and the government can decide to go beyond them when it believes necessary. Mary Ellen talked about a strike in Pakistan after May. After this big speech saying we're going to sort of restrict the use of force and scale back, in Yemen, over the span of about 14 days in July and August, there were 11 reported strikes, killing between 32 and 52 people, including children. This is after the NDU speech. The press quoted anonymous officials saying the government wasn't limited to striking alleged senior leaders, though even that person isn't necessarily a lawful target, even under the laws of war, but, quote, rising stars and drivers, for example, of al-Qaeda. One official suggested that the criteria were even looser. That person said that the barrage of strikes in Yemen in July and August was to buy time. So that's the criteria that was suggested. So I'll turn now to our litigation after just saying a bit about the impact. I mentioned our first case in 2010 challenging the authorization or challenging the constitutionality of the authorization for the killing of Anwar al-Awlaki in Yemen, who had been added to CIA and Joint Special Operations Command kill lists, the JSOC as a covert, sort of the covert counterpart to the CIA in the military. On September 30th, 2011, the CIA and JSOC carried out that authorization and killed al-Awlaki along with another U.S. citizen, Samir Khan, and 2 Yemenis. 2 weeks later, on October 14th, 2011, U.S. drones fired missiles at an outdoor eating area in Yemen, killing 16-year-old Abdul Rahman al-Awlaki, who is Anwar al-Awlaki's son, Abdul Rahman's 17-year-old Yemeni cousin, and at least 5 others. So we filed a second case against the CIA and the military officials responsible for those strikes, challenging the constitutionality of those killings of Anwar, Abdul Rahman, and Samir Khan. And that case is now pending in district court. We just had oral argument in July, and we're waiting for the court's decision now. Our legal argument in both cases was pretty similar. It was, one, asserting that the U.S. is not at war in Yemen. It was not at war in Yemen at the time of these strikes. That the usual rules that protect against the deprivation of life apply, not the exceptional rules of the laws of war. That under the usual constitutional and international law rules, the government can't take life without judicial process, except as a last resort in the face of an imminent threat. And all feasible precautions must be taken to protect civilian bystanders. That's a very tight standard. And that the circumstances of all 3 killings violated those standards. So, for example, carrying out a standing order to kill, an order that decides in advance to kill a specific person, flies in the face of the idea that there must be imminence at the time lethal force is used, and that lethal force is a last resort at the time it is applied. And that carrying out a strike on a public restaurant in plain view that results in the deaths of 7 people, including 2 children, suggests that reasonable precautions were not taken to protect bystanders from harm. We have an argument in the alternative, too, that says that even if you accept that this was armed conflict and that the laws of war apply, the killings were still violations of the laws of war, which still have constraints. Just because we're talking about war and the laws of war doesn't mean there can be indiscriminate killing. Even in that context, there are constraints on who could be targeted. There must be precautions to protect civilian bystanders, and there's prohibition on excessive harm to civilians. So we argue that even under those rules, the deaths of these 3 people were illegal. But in order for their claims to be heard in court, our clients have to first get through the courthouse door, which the government has tried to keep shut in virtually every national security-related case since 9/11, whether we're talking about arbitrary detention, torture, rendition, or killing, whether by U.S. or foreign citizens, and whether it's for an ongoing deprivation or a violation after the fact. In our case, in this case, it's pending now, the government similarly moved to dismiss, making a combination of arguments about the separation of powers and immunity for these officials that basically boiled down to a single assertion that the courts should have no role at all in reviewing claims of constitutional violations by U.S. citizens in this case, when those claims may relate to national security. So we're now waiting for the court's decision. In defending the government's position against judicial review, administration officials have protested that their actions are in fact not unchecked because Congress retains robust oversight. So it's okay if the courts, that does merit a laugh. Yeah, it's okay that the courts can't get involved. We've got robust internal processes within the executive, which the district court judge in our oral argument didn't exactly buy. As she said, the executive is not an effective check on the executive. But that Congress also has robust oversight. So in March of 2012, last year, Eric Holder said in a speech at Northwestern Law School that, quote, the executive branch regularly informs the appropriate members of Congress about our counterterrorism activities, including the legal framework, and would, of course, follow the same practice where lethal force is used against U.S. citizens. He said that in a speech to Northwestern law students. A year later, after the DOJ white paper was leaked, and which sort of sparked the greatest moment of debate we've had in Congress yet, we can question why that happened when it was about U.S. citizens, given that thousands of foreign citizens have been killed for years since 2009. But putting that aside, the head of the Senate Judiciary Committee, Patrick Leahy, told Holder that he was considering subpoenaing the administration for its legal memos on targeted killing out of frustration that he had asked repeatedly, the committee had asked repeatedly, and they had not been provided. So this is a year after Holder says to the public, don't worry, there is robust congressional oversight. Since then, there are certain Senate and House committees that have been given access to the memos discussing the legal authority to kill U.S. citizens, but not those discussing the legal authority to kill foreign citizens, so therefore not the memos that discuss the legal authority about most of the program. And the vast majority of Congress has not seen any of it. So that's so much for informing Congress. As for informing the public, the numbers I stated at the outset and the stories we know come entirely from non-governmental sources. Many of the journalists and activists in this room that you'll hear from this afternoon. There's not a single data point that the administration has provided in terms of who has been killed, why they were killed, where they were killed, what the legal basis was for each of those deaths. Of the 4,000 or more potentially who have been killed, the administration has openly acknowledged responsibility for exactly 4. All U.S. citizens. In May, the day before the big NDU speech, Eric Holder sent a letter to Congress openly, directly acknowledging what the world knew, but that the United States had in fact carried out targeted killing operations that resulted in the deaths of 4 U.S. citizens, Anwar al-Awlaki, Samir Khan, Abdul Rahman al-Awlaki, and Jude Mohammed in Pakistan. And of those 4, it went on for several pages about its accusations against Anwar al-Awlaki, and it had one line to say about the other 3 citizens, and that was that they were not specifically targeted. For the thousands of others, as I said, it continues to refuse to say anything about who, how many, why, where. What it has seen fit to disclose are, again, in half a dozen official speeches, a White House fact sheet, and anonymous leaks to the press. So that's as far as our case. One last point I wanted to make before closing and turning it over to Marjorie is that alongside our efforts for accountability and alongside a lot of, I think, of all the issues, there's sort of the most consensus on transparency and judicial review, and that's important and good. But alongside those demands, I think it's clear that we need to equally press a strong legal, moral, and political critique based on what we do know, what has been said, and what we do know. And I say that in part as someone who has worked on Guantanamo for years, and sort of a lesson learned. A lesson learned from that experience, where there was a great deal of focus on transparency and just getting these guys into court and getting judicial review. We got the review we fought for years, and it has ultimately been empty. So I think that experience for me has really underscored the importance of a deeper critique up front alongside those legal strategies. So thank you very much.
Thank you, Pardiss, and thank you for your really, really critical legal work in this area and for CCR's work. Both the Bush administration and the Obama administration have justified their targeted killing policies with reference to the authorization for the use of military force, or the AUMF, which Congress passed a week after 9/11. It authorizes the president to use all necessary and appropriate force against those nations, organizations, or persons he determined, and listen to this, planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. This organization is limited to groups and countries that supported the 9/11 attacks. Congress specifically rejected the Bush administration's request for open-ended military authority to deter and preempt any future acts of terrorism or aggression against the United States. But deterrence and preemption are exactly what Obama is trying to accomplish by sending robots to kill suspected militants. And I also want to say that even if the AUMF did cover what he's doing now, it would still be illegal for the reasons that Mary Ellen pointed out, that it violates the UN Charter. The UN Charter is the grandmother treaty of them all. And when the United States ratifies a treaty, it becomes part of U.S. law under the Supremacy Clause of the Constitution that says treaties shall be the supreme law of the land. So one of the takeaways from this session is that next time you hear someone drawing a dichotomy between U.S. law and international law, make sure you tell them that if we've ratified a treaty, it's part of U.S. law. Some people on the Supreme Court don't understand that. In February of 2013, a Department of Justice white paper was leaked to the press, and Pardiss referred to this. It describes the circumstances under which the president could order the targeted killing of U.S. citizens. Now, there had not been a large outcry in this country about the targeted killing of non-U.S. citizens, but as soon as many people in this country learned that maybe U.S. citizens would be targeted, there was a huge outcry. Senator Rand Paul mounted a filibuster, and people were very upset that U.S. citizens might be killed. And this spurred Archbishop Desmond Tutu to write a very, very poignant letter to the editor in the New York Times saying, how dare you say that U.S. lives are more precious than lives of other people. So when I put together this anthology that Medea referred to, and Medea and Pardiss both have chapters in the book, I thought, well, who do I want to write the foreword to the book? Well, of course, Archbishop Tutu. And he agreed, and that is the premise for the foreword to the book, because I think that's one of the really key things, based, of course, this distinction between U.S. citizens and non-U.S. citizens, based on nothing other than, well, I should not say nothing other than, but certainly overwhelmingly based upon racism and also this xenophobia that America is exceptional, that U.S. citizens are more valuable than citizens of other countries. And that's something that we really have to take head on and just disabuse that notion every time we can. Now, in May of 2013, as international criticism targeted Obama's drone policy and the continued indefinite detention at Guantanamo, where detainees were starving themselves to death and military guards were violently force-feeding them, which amounts to torture, the president delivered a speech, and Pardiss referred to that speech. Obama explained, and I'm going to go like this when I'm quoting, "The United States is at war with al-Qaeda, the Taliban, and their associated forces." He didn't define who those associated forces are. And although he defended his use of drones in targeted killing, Obama proclaimed, "America does not take strikes when we have the ability to capture individual terrorists. Our preference is always to detain, interrogate, and prosecute them." Obama referred to the killing of Osama bin Laden as exceptional because capture, although our preference, was remote. Yet it was clear when the U.S. soldiers arrived at bin Laden's compound that the people there were unarmed and bin Laden could have been captured and brought to trial. Obama admitted the cost to our relationship with Pakistan and the backlash among the Pakistani public over encroachment on that territory was so severe that we are now just beginning to rebuild this important partnership. In view of Pakistan's considerable arsenal of nuclear weapons, Obama took a substantial risk to our national security in breaching Pakistan's sovereignty by his assassination operation. As Obama delivered his remarks, the White House issued a fact sheet containing policies and procedures for counterterrorism operations, but did not release the full presidential policy guidance. The fact sheet says, "The policy of the United States is not to use lethal force when it is feasible to capture a terrorist suspect. It provides that lethal force will be used outside areas of active hostilities only when certain preconditions are met, but it does not define areas of active hostilities." A target must, this is according to the fact sheet, a target must pose a continuing imminent threat to U.S. persons. The fact sheet does not define continuing or imminent, but as Pardiss said, the leaked Department of Justice white paper says that a U.S. citizen can be killed even when there is no, and I'm quoting, "clear evidence that a specific attack on U.S. persons and interests will take place in the immediate future." That renders the imminence requirement a nullity. There must be near certainty that a terrorist target is present, that non-combatants will not be injured or killed, and that capture is not feasible, also left undefined. Now, the way that the Obama administration defines civilians is very creative. If someone is a male between the ages of about 16 and 65 and located in an area of suspicious activity, then you are not a civilian unless you're posthumously declared to be a civilian. So, after you're dead, of course, there can be a clarification that you really were a civilian. And Obama mounts two different kinds of strikes: personality strikes that target individuals, and signature strikes that don't target individuals, that target areas of suspicious activity. So if you're found in an area of suspicious activity, you happen to be walking through, you are fair game for Obama's targeting. And as you probably all know, the New York Times had a large expose on Obama's kill list, which John Brennan, who was involved in CIA torture during the Bush administration, then became the counterterrorism advisor for Obama and is now our CIA director, which should warm your hearts. This kill list, once a week on Terror Tuesdays, they sit down and Obama makes the final decision on who is going to assassinate that week. So back to the fact sheet. A showing must be made that governmental authorities in the target country cannot or will not effectively address the threat to U.S. persons, also left undefined. A showing must be made that governmental authorities in the target country cannot or will not, I'm sorry, I already said that, and no reasonable alternatives exist. A legal basis is required for the use of lethal force, but the fact sheet fails to define that legal basis. Whatever it may involve, it surely includes, it surely violates treaties ratified by the United States, including the UN Charter. But unfortunately, from what Mary Ellen said about Harold Koh's position, that may not be the case. The fact sheet would excuse all of these preconditions when the president takes action in extraordinary circumstances, which are both lawful and necessary to protect the United States or its allies. No definition of extraordinary circumstances. Now, the concern about drone strikes has entered the national discourse, and some in Congress have begun to hold hearings, and some legislation has been introduced in Congress, and I'm just going to briefly talk about some of that. The first hearing on the use of drones for targeted killing took place in April of this year, and the hearing was called by Senate Majority Whip Dick Durbin. But the Obama administration failed to participate. Although they were invited, they didn't send any witnesses. What we should be asking is, why not? Why not? No bills have been passed, but some have been introduced into Congress. So let's briefly look at some of these bills. Representatives Mike Burgess and Chris Gibson have introduced a bill prohibiting the use of drones as weapons or as weapon delivery systems within the United States. Nobody has introduced a bill prohibiting or limiting it outside the United States, although there's some reference to that, and I'll talk about that. Ted Cruz, you've heard of him. Mike Lee and Rand Paul have introduced bills outlawing the use of drones within the United States to kill American citizens. Darrell Issa, who unfortunately comes from my neck of the woods, and also Meadows, Nunnally, Enyart's a Democrat, the other three are Republicans, have introduced a bill about targeted killing. It's a little more specific than the other ones, and it reads in pertinent part, a federal department or agency or the armed forces may not deliberately target a citizen of the United States or a citizen of a strategic treaty ally of the United States in a pre-planned lethal operation unless the pre-planned lethal operation is planned and executed pursuant to a written determination signed personally by the president, confirming the status of the targeted citizen as an enemy combatant, and authorizing the deliberate lethal targeting of the citizen based on the articulated need for such action. But, it says, nothing may be construed to authorize the deliberate targeting of a U.S. citizen inside the territory of the United States. Now, I just want to say a few words about the use of drones within the United States. In February, Congress voted to make the Federal Aviation Administration allow drones to fly in U.S. airspace by 2015. 4 states have already passed legislation limiting the use of drones within their borders, and 32 states have pending legislation to limit the technology. At a May hearing this past May, the House Judiciary Committee's Subcommittee on Crime, Terrorism, and Homeland Security and Investigations discussed legislation to protect Fourth Amendment rights without limiting the potential benefits of drones. And there are some potential benefits. They can be used to find missing children, help put out forest fires. I have a friend who has a photography drone where he has a little iPod or iPhone hanging from a drone that flies around and takes pictures. That's not the drones that we're concerned about. Police use drones for surveillance. They're doing this more and more. And this is not just to catch the criminals. It's also to surveil people engaging in lawful dissent, because this government has a history for many, many years, from the beginning, in fact, for targeting dissenters, notwithstanding what the First Amendment says. The Border Patrol, okay, this is my last sentence. The Border Patrol wants to use armed but non-lethal drones, I think that means rubber bullets, to police the border. That has not been approved yet, but there are some moves to include that in an immigration bill. So we need to use, still the same sentence, we need to use all the tools we have. We need to use political tools through Congress. We need to use political tools through direct action and legal tools to stop this madness. Thank you.